instance, in Estelle v. Smith, the police were required to read the petitioner his rights. And later, in a separate investigation where the psychiatrist was interrogating the petitioner, they had to read him his rights once again. But this did not happen in the case at bar. Mr. Denault
Counsel, you only have to read someone their rights if they're in custody and they're being interrogated. So show me how they are being in custody and they are being interrogated here then.
Your Honor, respectfully, we would argue that even if Mr. Denault was not in custody, a custodial interrogation could still happen. We turn this court's attention to Harriman v. Estelle, as cited in Pennsylvania v. Munoz, where this court held that, quote, custodial interrogations for purposes of Miranda include both express questioning and also actions that have the force of a question on the accused and therefore be reasonably likely to elicit an incriminating response, end quote. If the police have the intent of eliciting an incriminating response from a suspect through testimonial means, then we would argue that it is a custodial interrogation setting and Miranda rights ought to have been read. But in the case at bar, the Miranda rights were never read. And moreover, Mr. Denault was misinformed about the procedure and the actual test itself. He was told that this FBME test was procedural, like taking a fingerprint or a blood draw.
Okay, you just mentioned fingerprinting again. So if the technicians had found fingerprints at the crime scene and they had, asked him to submit for fingerprinting, which is, as you said, procedural, would you have considered that evidence testimonial?
Absolutely, Your Honor. Absolutely not, Your Honor. And this leads us to the second prong of the test, which delineates physical and testimonial evidence. In Doe versus United States, this court established a standard, which is that testimonial evidence is evidence that comes from one's mind. And physical evidence is evidence that one could tangibly see or essentially
Counsel, how is this different? How is this testimonial evidence? How is this different than let's say somebody asking for a handwriting sample or a fingerprint?
Your Honor, in Gilbert v. California, as cited in Schmerber v. California, this court explicitly stated that with a handwriting exemplar, while looking purely at the handwriting would be physical, if they were looking into the content of what was being written, then that would count as testimonial as we believe that
the content of his mind. They didn't see anything like, what he was thinking about the picture that he was shown. There was no content that was elicited here. So how is this, I agree with Justice Wagner. How is this the same?
Your Honor, our argument would be simple, and we submit that the means don't justify the ends. Even if the means of the FBME machine were physical in the sense that it was simply scanning the neurological flashes of one's brain, the intent and the end goal of the FBME test is to use Mr. Denault's memories against him.
Counsel, let me stop you, because how is this a testimonial communication? I know you're citing the cases, and I've read the cases. But I want to know, when you apply the cases to the facts of this situation with this specific test, why did your client give testimony here as opposed to just providing some kind of other kind of information that normally would be constitutionally permissible for law enforcement to take? Specifically apply that rule of law that you read to us and tell us why what your client did was give testimony. How is it testimony?
Your Honor, it looks like my time is expiring. May I answer your question and briefly conclude?
You certainly can, and then briefly conclude.
Thank you, sir. In this specific case with the functional brain mapping exam, it's testimonial because it reveals knowledge. Page 3, paragraph 2 of the facts of record explicitly state that memories are required for the FBME machine to work. With a blood draw or a fingerprint, it doesn't reveal knowledge. All it does is show whether or not a physical aspect of the body, or rather that physical aspect, incriminates the suspect or not. But with the case of the FBME, they use physical aspects in order to ascertain whether or not Mr. Denault, or any suspect for that matter, has knowledge of being at a certain location, which blatantly goes against this court's precedents set in Doe versus United States. So because, Your Honor, we believe that both prongs, or all three prongs at that matter, were upheld in the case at bar, we would ask this court to reverse the decision of the lower court of appeals. Thank you.
Thank you. Second petitioner, you may proceed.
Thank you. Madam Chief Justice, Associate Justices, and may it please the court. My name is Luke Spencer, and I rise to continue argumentation on behalf of the petitioner, Mr. Denault, and his Eighth Amendment claim. our Constitution has always forbidden punishments that are found to be both unnecessarily cruel and blatantly unusual. In the instant case, Mr. Danoff has been sentenced to 30 years in solitary confinement in an abnormal way and without reason. Because of this, his Eighth Amendment rights were violated. We therefore ask to reverse the lower court's decision. To this end, the petitioner would submit 2 lines of argumentation. First, that prolonged solitary confinement is objectively cruel. And second, that the facts found within the instant case prove this punishment to be unusual. In regards to the first line of argumentation, the petitioner would like to clarify that not all prolonged solitary confinement is unconstitutional, but rather that all prolonged solitary confinement is cruel. This court explains in Gregg v. Georgia on page 994, paragraph 3, that although severe mandatory penalties may be cruel, they are not unusual in the constitutional sense. Likewise, we would contend that prolonged solitary confinement by its nature is cruel. And we can see this in the first
Counselor,
2 prongs.
I'm understanding the cases again, but I need you to apply them to the facts of this case. Why is being in prison, cruel in this kind of setting? We'll get to. I've got a bigger question of why it's unusual in a minute, but how is this cruel? There were days when they tore off arms and they did very bad things to human beings for punishment. How does this fall into that category of what the founders were trying to prevent when they said we don't want anything that's cruel and unusual?
Your Honor, our precedent says within the case of Farmer v. Brennan, as cited within the case of Porter v. Clark on page 361, paragraph 1, that a punishment is cruel when it creates a substantial risk of serious emotional or psychological harm. In order to prove this risk, I'd move our court's attention to page 357, paragraph 2 of Porter, where we are given 5 different cases that have all found, based on empirical scientific evidence, that prolonged solitary confinement creates this risk. This is seen in the cases of Akuma v. Sterling, Pelvac v. Wetzel, Ashker v. Brown, Wilkerson v. Stalder, and McClary v. Kelly. From these studies, we can conclude that prolonged solitary confinement is objectively cruel. But before proceeding, it's important to note that on page...
Mr. Spencer, we've read those cases again. But what we're asking you is, how is it cruel? I know those cases say they're objectively cruel. Why are they objectively cruel?
Your Honor, the test set within Farmer v. Brennan was essentially supposed to be applied to a certain punishment. And if that punishment of solitary confinement, prolonged solitary confinement, fulfills that test, then according to our precedent, it is considered cruel. Because prolonged solitary confinement creates a substantial risk of serious emotional and psychological harm, our precedent indicates that it is cruel. Now, on page 363, paragraph 1 of Porter v. Clark, they explain that a penological justification can support these so-called cruel conditions. The petitioner would have to
that there's no standard with regard to what precisely cruel and unusual is.
Can you repeat your question, Your Honor? There's a loud noise.
Okay, isn't it true that there's no standard with regard to what precisely cruel and unusual?
Yes, Your Honor. The cruel and unusual prong within the Eighth Amendment does evolve with society, but there are specific prongs or tests that can be applied to different punishments to determine when a punishment is cruel and when it is unusual. When we turn to the idea of a penological justification, the petitioner would have 2 responses to this claim. First, that there is no valid penological justification, and second is that even if there was, it could not justify an unconstitutional punishment. In regards to the first line of argumentation, the petitioner would like to emphasize the fact that the justification must be valid. According to the majority of Foreman v. Georgia, as cited in the dissent of Gregg v. Georgia, the question put before court when determining the validity of a penological justification is whether a punishment is necessary to accomplish the justification or whether a less severe penalty would serve the same purpose. This leads us to the justification provided in the instant case. Page 13, paragraph 6 of the majority explains that the state provides a justification of deterrence. While it is true that in general deterrence is a legitimate penological aim, We would contend that it is not within the instant case simply because solitary confinement is not needed to deter murderers. Something far less cruel, such as life without parole, would serve the same purpose. And this sentiment is backed up in Ewing v. California on page 29, paragraph 3, where they explain that Ewing's sentence of life without parole is justified by the state's interest in deterring felons. This lack of justification.
Let me move you to the unusual side of things, because you got to show that it's unusual as well. And, you know, there are 80,000 to 100,000 inmates in prison right now that are in solitary confinement. So that suggests, does it not, that solitary confinement is not an unusual punishment? And if it doesn't, tell me why it doesn't in this case.
Your Honor, we would contend that this use of prolonged solitary confinement is unusual in 3 ways. It's unusual in the misuse of solitary confinement. It's unusual in their clear, deliberate indifference to Mr. Denoff's mental health conditions. And it's unusual in the unnecessary cruelty. In regards to the misuse of solitary confinement, we point this court's attention to page 7, paragraph 1 of the record, where they explain that Olympus is the only state within our entire nation that allows judges to use solitary confinement as a punishment. When we turn to page 8, paragraph 1 of the record, they explain that federally, solitary confinement is solely used for either disciplinary reasons, for an inmate's actions within a prison, or for administrative reasons, such as an inmate is under investigation. The facts indicate that this punishment is not only unusual, but non-existent out of the state of Olympus. But we also contend that this punishment is unusual in their clear, deliberate indifference. According to Farmer v. Britton on page 361, paragraph 2, in order to prove deliberate indifference, plaintiffs must show that officials knew of and disregarded an excessive risk to inmates' health and safety. In the case of Rick v. Shover, as cited in Porter v. Clark, on page 362, paragraph 3, they explain that if a prison official lacks a legitimate penological justification for subjecting an inmate to prolonged solitary confinement, the official is presumptively acting with deliberate indifference to that risk. The state of Olympus has no valid reason to subject Mr. Denoff to these conditions. And as Wilkerson v. Utah, as cited in Gregg v. Georgia on page 17, paragraph 2, explains that it is safe to affirm that punishments in the same line of unnecessary cruelty are forbidden by the Eighth Amendment.
Okay, Counselor, one of your justifications for that, you know, obviously this shouldn't be happening, is that there was a disregard of Mr. Denoff's mental health issues. But you would agree with me that Mr. Denoff was found to be of sound mind, and that in a court of law, there were no problems with him testifying. He was fine. And that they even said that depression is common in inmates who are serving long sentences. So it's not even out of the usual. Like, how is this a disregard for mental health issues when it seems as though they don't necessarily exist to the court?
It appears I've ran out of time. May I briefly answer that question, Madam Chief Justice?
Please do and conclude.
Thank you. Your Honor, we would contend that the state of Olympus is showing a deliberate indifference to the risk of psychological deterioration. The state of Olympus has no valid reason to subject Mr. Denoff to an objectively cruel punishment that poses a substantial risk. And in that regard, they are showing a deliberate indifference to the substantial risk. The state of Olympus may have some sort of medical care, and Mr. Denoff may have committed a heinous crime, but he does not deserve a punishment that is, 1, objectively cruel, 2, done without a legitimate reason, and 3rd and finally, unusual in every sense of the word. It's for that reason we'd ask this court to reverse the lower court's decision. Thank you.
Thank you. Respondents, are you ready to proceed?
Yes, Your Honor.
Great.
Thank you, Your Honor.
Whenever you're ready.
Madam Chief Justice, Honorable Associate Justices, and may it please the court. My name is Nathaniel Mowry, and I, along with my co-counsel, McCoy Conlon, stand on behalf of the state of Olympus. My co-counsel will be addressing the Eighth Amendment issue, while I will be addressing the Fifth Amendment issue. It is because the government did not violate Mr. Denoff's Fifth Amendment privilege against self-incrimination that the 12th Judicial Circuit Court's decision should be affirmed, specifically for 2 main reasons. First of all, that Mr. Denoff did implicitly consent to the FBME. Second, the FBME does not violate the Fifth Amendment in general, and therefore Mr. Denoff's Fifth Amendment rights were not violated. But before we move into our arguments, we would like to make 2 factual clarifications about petitioner's case. Now, first of all, opposing counsel said that Mr. Denolf was compelled. Opposing counsel also said that compulsion is not limited to your physical freedom being limited, but this is not the precedent of this honorable court. One's freedom of action has to be significantly curtailed, and respondent would argue that this court meant that your freedom of action has to be curtailed. Your physical freedom of action has to be curtailed, which did not happen in the case at bar, as this honorable court proved through the many questions asked by this court to petitioner. Miranda rights have never, via this court's precedent. Yes, Your Honor.
This guy was not really free to go, was he?
Your Honor, from his perception, he was free to go, Your Honor. And that's what this court has...
I didn't ask that. I'm talking, you're representing the government here. The government wasn't going to let him walk out the door, were they?
Your Honor, to say that they wouldn't have let him is speculation and outside the facts of the record, so I do not believe I can answer that question appropriately, respectfully.
Well, but from the facts, we do know that they were conducting an interrogation in a certain way, and they were intending on eliciting incriminating information from the defendant. Isn't that correct?
Your Honor, I would say that for this criminal investigation, it was the duty of the government to try to find that information, and they were trying to find out who murdered Miss Somerville, Your Honor.
Right, but they were not. When they conducted this test, they weren't doing it to exclude him or to show his innocence, correct?
Well, Your Honor, they were trying to find out the facts, Your Honor. So they could have been trying to prove his innocence. They were just trying to find out who murdered Miss Somerville, Your Honor.
Good, thank you.
Now, Your Honor, if we look at the functional equivalent to custodial interrogation or express questioning, this court has said that, quote, any words or actions on the part of the police, other than those normally attended to arrest in custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. The latter portion of this definition focuses primarily upon the perceptions of the suspect rather than the intents of the police, unquote. And if we look at the perception of Mr. Denolf, his perception was that he could leave at any time. The police told him that he could leave at any time, so from his perception, he could leave at any time. Now, moving on to our second factual clarification, which was opposing counsel said that Mr. Denolf was misinformed. But let's turn to the facts of this case. The technician said that this test is like a blood test or fingerprint scan. He was not misinformed. The technicians described the FBME appropriately. The record states that the FBME has been called, quote, brain fingerprint.
Counsel. A blood test shows one, a fingerprint maybe show an identity, but this test expressly answered the question, were you present in the place where the crime occurred? And then gave the exact answer as if he had uttered it using his voice. But, you know, and you would agree that when somebody talks, their brain helps them, you know, and is part of the process that gives the answer, correct?
Your Honor, I would say that when someone talks, yes, their brain is used.
So I just asked you a question. Your brain answered the question for me. Now, doesn't this test just bypass that verbal response?
Your Honor, not necessarily. This does blur the line.
Though, did it?
I'm sorry, could you?
In this case, did it?
Could you repeat the question? So sorry, so I can.
Well, in this case, didn't the response that this test provided do the same thing as a law enforcement officer asking the question, but then just bypass the verbal response?
Your Honor, we would say that the same thing could be said about maybe even a blood test. If you look at the physical nature of a blood test, you could say that it reveals the contents of one's mind, such as one could say, I'm drunk. But instead of just making someone say that, the police could go around and obtain a blood sample. But this court has ruled that that is not testimonial. And like I said before, it does the exact same thing as a fingerprint. It does not prove that Mr. Denolf even committed the crime. It does not even reveal that when he was at the scene of the crime, just that he was somewhere at a certain point in his life. So with these clarifications, we can move on to our first argument, that Mr. Denolf implicitly consented to the FBME. Now, via the ruling of Enri Grand Jury Subpoena Ducis Tecum, there is a three-part test this court has used to decide if the Fifth Amendment has been violated, which petitioner already went over, which is if the information gained was testimonial, if the individual was compelled, and if the information was incriminating. Now, for a Fifth Amendment violation to have occurred, all three prongs of this test must be confirmed. But when we look to the facts of this case, we can easily see that the information was in no way compelled. If we look at the rulings of Estelle versus Smith, Pennsylvania versus Muniz, United States versus Hubble, and United States versus Kirshner, we find that all of these cases had some form of compelling circumstance which the individual explicitly knew about. These cases either had a subpoena forcing the individual to give information, or the individual was directly in custody, none of which occurred in the case at bar. According to the record, specifically page 5, paragraph 3, government officials asked Mr. Denolf if he would accompany them. He walked with them on his own accord all the way to the site. When they got to the site, the police officers actually left the room. At any point during this process, Mr. Denolf could have said that he was uncomfortable and wanted to leave, but he never did so. He went through with this test willingly, meaning he was never handcuffed or being held against his will, and he wasn't forced in any physical way to take the test.
He went through with this test willingly because the police told him it was procedural. They told him it was just like anything else they would do, like a fingerprint or a blood sample. I mean, they didn't tell him it was going to read his mind and figure out if he was at a certain place at a certain time or if he'd seen it before.
Well, respectfully, Your Honor, according to the facts of the record, it is becoming procedural in the state of Olympus. So they were not lying.
Procedural, but it is not the same as those other procedural tests. I understand, and that's great, that if the police is going to start using it more and more, it is technically considered procedural. But don't you think that it's a little bit odd that they didn't tell him exactly what it was going to do? Isn't that misleading?
Well, Your Honor, respectfully, they did tell him what it was going to do. They told him it would be like a fingerprint or blood scan test. And they also
fingerprint read your mind?
Your Honor, a fingerprint can very potentially easily reveal where you have been in the past, Your Honor.
But can a fingerprint reveal what you're thinking?
Your Honor, yes, it can, because it can reveal that you were at a certain place at a certain point in time.
But counsel, that's not revealing what you think. It's revealing the same conclusion, but one is achieving the conclusion because it's learning what you thought, and the other is matching a print for where you are for where you were. But on the custodial interrogation, this was law enforcement officers, right? Were they dressed? Do you know if the record shows whether they were dressed in uniforms or not?
Your Honor, the individuals who completed the FBME procedure were technicians, and they were working for the police department. The record does not specify whether they were in uniform or not.
No, who walked them down to that place, though?
Oh, but I believe it was the investigators, Your Honor. So
And were they dressed in law enforcement? You know, I mean, it was clear that they were law enforcement, correct?
I would assume so, Your Honor. The record.
So they likely would be having firearms with them, correct? You know, and don't you think all that kind of authority with firearms and badges, and you're in a police station, you know, do you really feel that this guy thought in his mind that he could walk away at that point?
Your Honor, the police officers told him that he could leave at any time, multiple times. So as respondent, I would argue that yes, he was not compelled in any way. He was given the choice to leave multiple upon multiple times, and he never did so. So according to the facts of the record, Mr. Denolf did implicitly consent to this test. So even if this court does find that the information may possibly be testimonial, Your Honor, I see that my time has expired. May I finish that thought and briefly conclude?
Please do.
Thank you, Your Honor. So even if this honorable court does find that the information may possibly be testimonial, it was in no way compelled. It's for the reasons presented to this honorable court that the lower court's decision should be affirmed. Thank you.
Thank you.
May I proceed, Your Honor?
Whenever you're ready.
Thank you, ma'am. Madam Chief Justice, and may it please the court. My name is McLean Conlon, and I represent the respondent, the state of Olympus, on the Eighth Amendment issue. On March 17th, 2020, William Denault, a 55-year-old real estate agent, tortured a young school teacher to death in a local hotel. After being tried and convicted for murder, Mr. Denault was sentenced to a minimum of 15 years in solitary confinement on account of the extremely violent nature of his crime and to ensure the safety of his fellow inmates. This decision was in full compliance with the Constitution, common sense, and this court's precedents. We present two arguments. First, the conditions of solitary confinement at Poseidon Penitentiary are neither unusual nor cruel, and thus, under this court's holding in Rhodes versus Chapman, they cannot be unconstitutional. And second, the state of Olympus has a legitimate penological justification for sentencing Mr. Denault to solitary confinement, as required by Ewing versus California. Before I get into my main arguments today, Your Honors, I'd like to make one brief factual clarification. Opposing counsel said that Mr. Denault was subjected to deliberate indifference because he was denied basic medical care. However, this is simply not true. Page 10 of the facts of the record explicitly states that, quote, psychiatric treatment and medications are available on site, end quote. In other words, all Mr. Denault had to do was ask and he would have been provided with immediate psychiatric care. Now, turning to the main points, Your Honor, beginning with my first point about this not being either cruel or unusual. In Rhodes versus Chapman, this court declared that, quote, conditions that cannot be said to be cruel and unusual under contemporary standards are not unconstitutional. To the extent that such conditions are restrictive and even harsh, they are part of the penalty that criminal offenders pay for their offenses against society, end quote. In other words, the Eighth Amendment does not prohibit every punishment, which may be uncomfortable, but only those which violate contemporary standards of decency. Abandoning this limitation will allow courts to impose their own preferences onto the penal system without looking first to objective standards. In the case of Thompson versus Oklahoma, this court used that test to hold that capital punishment for inmates who are under 16 violates the Eighth Amendment. However, in reaching that conclusion, this court set a very high bar for when a punishment is unusual. It pointed out that nearly 2/3 of states had abolished the death penalty for juveniles, and that no jury had actually imposed this punishment in nearly 50 years. Turning to the case at bar, we find that this remarkably strict standard is in no danger of being met.
Well,
According to
counsel,
page 6,
are you sure
Yes, sir.
about that? You know, I mean, this is the only state, Olympus is the only state in the union that allows a judge to sentence somebody to solitary confinement like our judge did here. Most of the time, it's usually used, you know, as a matter of punishment. Now, I know your colleagues on the other side, I gave them a hard time that there are 100,000 people in solitary confinement, but most of those people are in there because they did something bad and they're not going to be in there forever. You know, how is this not unusual that this is the only state and the only place in the country that this kind of sentence can happen, and it happened to this guy?
Absolutely, Your Honor, and we have two responses to that. First of all, that is simply incorrect what opposing counsel said. At least 15 states automatically sentence gang members to solitary confinement, even if they have not committed any offense while in prison. And second of all, you're placing inmates logical justification, namely incapacitation. In Ewing versus California,
to the point of it being unusual, you said that they immediately place gang members in solitary. Well, that's clearly because they're gang members and there's a higher risk of them getting injured or in some kind of altercation when they're in prison. So I mean, that's not the case in this scenario.
Respectfully, we disagree with that, Your Honor. Mr. Denault, by committing a violent crime, has shown that he is likely to harm another human being again in the future. And nothing in the Constitution requires prison officials or judges in this case to wait until he's harmed someone in prison before they can impose solitary confinement. Now, to Justice Wagner's point, we agree that if he was in solitary confinement forever with no possibility of being released, this could violate the Eighth Amendment. However, that's not the case here. According to the facts of the record, Mr. Denault can be released early if prison officials determine that he no longer poses a credible threat. Now, opposing counsel brought up the case of They do not, Your Honor. However, there's nothing in the Constitution or this court's precedents which sets a certain date by which he must be released. And there's a reason for that. The record states that if someone's in solitary confinement for more than 10 days, they suffer negative psychological effects. However, if this court used that rule and made it literal and said nobody can ever be placed in solitary confinement for more than 10 days, What if someone is still showing violent signs at 11 days? Prison officials need the discretion to make these decisions because they are the ones who are evaluating information firsthand. And so long as those decisions are reasonable, this court should defer to them like it did in Harmland versus Michigan, recognizing that state legislatures and judges and prison officials are the best ones to make immediate, reasonable decisions. Now, opposing counsel brought up the case of Porter versus Clark from the Fourth Circuit about 5 years ago, and this is probably the best case for them in the record. However, what they left out is that in Porter versus Clark, the majority explicitly conceded that, quote, prolonged solitary confinement can be justified by a legitimate penological justification, even if it creates a risk of psychological harm, end quote. The majority also said that one can be placed in prolonged solitary confinement, quote, if he poses a credible risk to the safety of his fellow inmates, end quote. That's exactly what happened here, Your Honor. Mr. Nolf did not commit a nonviolent crime like tax fraud and then was placed in solitary confinement. He committed a violent crime, namely murder and torture, and then was placed into solitary confinement. As a result, the judge's decision in this case was reasonable, Your Honor. Opposing counsel tried to propose an alternative by saying, what if he was simply given life imprisonment instead? However, what they forget with this is that that punishment would not fulfill the goal of incapacitation. Life imprisonment would still leave Mr. Denolf in the general prison population, free to commit another violent crime against another inmate. Now, to be clear, Mr. Denolf, if prison officials determine he reforms himself and he is no longer a credible threat, he can be released. But if he is not, they need the discretion to keep him there until he does do so. Now to address the specific conditions at Poseidon Penitentiary, whether or not they are actually cruel. Now, the American Correctional Association actually evaluated the conditions at Poseidon and determined that they were adequate because they include access to a pastor and spiritual counseling, access to a mental health professional, the ability to meet with family and attorneys, or the ability to contact family and friends, the ability to meet with one's attorney, the ability to request books and reading materials, and at least once a month, Mr. Denolf is able to interact with other prisoners. He simply can't physically touch them. So in other words, Mr. Denolf is not cut off from all human contact. What he is cut off from is all physical human contact. And there's a reason for that. Mr. Denolf, the state has a moral and constitutional obligation to meet his basic health needs, like human contact, but it does not have an obligation to place him in a situation where he can harm another human being. The state of Olympus has found a legitimate compromise here, allowing Mr. Denolf to interact with other human beings, but never putting him in a position where he could physically harm them. Now, in the case of Helling versus McKinney, brought up by opposing counsel briefly, in that case, prisoners were suffering significant medical harms from secondhand smoke, and prison officials did nothing to stop it, and they showed deliberate indifference by denying basic care. That is not the case here, Your Honor. As I mentioned at the beginning of my argument,
how can you justify your denial of medical and mental health checkups for Mr. Denolf?
there are no regular checkups. That is correct, Your Honor. However, prison guards do receive basic health training, and if they notice any problems or believe simply Mr. Denolf needs to speak with someone, they can go out of their way and arrange a meeting. And furthermore, even if prison guards don't agree with that, Mr. Denolf can, of his own accord, ask to speak with a mental health professional, and the state has a legal obligation under Olympus law to provide that professional. They are also obligated to provide any appropriate medicine that he might need, as well as to simply allow him to speak with another human being. He is not cut off from all human contact. He is given a variety of options to meet those needs. He has simply refused to take advantage of them, and the state is not responsible for that, Your Honor. And furthermore, opposing counsel completely left out the precedent of this court 17 years ago in the case of Wilkinson versus Austin, as cited in Porter versus Clark. In that case, a plaintiff tried to bring a case against solitary confinement in Ohio under extremely restrictive conditions, and this court upheld the use of solitary confinement in Ohio. Okay, I'm sorry, I just dropped. Did everyone else drop as well?
Yes.
Okay,
You were starting
well-
your quote, and then I didn't hear you anymore.
Oh, darn it. Well, thank you. Well, so I got 20 seconds left and I'll make it quick. Thank you. So for Wilkinson versus Austin, this court upheld it because the inmates had access to counseling. Exact same case here. Petitioners have to explain why Wilkinson no longer applies. And second of all, your honors, they have to explain what's the alternative in the case at bar. Is it simply life imprisonment without solitary confinement? Well, that would put the safety of other inmates at risk. Is it allowing Mr. Denolf to be released from solitary confinement early? Well, the state already did that. Prison officials have that discretion. There is simply nothing more the state could do that would guarantee the safety of other inmates. And for this reason, we respectfully ask this court to abide by its prior precedents and uphold the use of solitary confinement for our most violent offenders. Thank you, Your Honor.
May I proceed with rebuttal, Your Honors?
Whenever you're ready.
Thank you. May it please the court. In this rebuttal, the petitioner provides two lines of refutation. First, regarding the Fifth Amendment, and second, regarding the Eighth Amendment. In regards to the Fifth Amendment, opposing counsel contended that Mr. Denolf was not in custody, and for that reason, his Miranda rights did not need to be read. This is patently false pursuant to Pennsylvania v. Muniz, where they held that, quote, when the physical nature of a test begins to yield testimonial and commutative statements, the protections afforded by Miranda are invoked. Opposing counsel also contended that Mr. Denolf voluntarily took the FBME. We would again disagree. Miranda v. Arizona explicitly states that a defendant may waive his rights provided the waiver is made voluntarily, knowingly, and intelligently. Page 5, paragraph 3, the record explains that Mr. Denolf was only told that this test was procedural. He was never told that it was optional and that it would be used in a court of law to incriminate him. For that reason, Mr. Denolf was compelled. Now, opposing counsel contended that the information extracted from the FBME was like a fingerprint in the sense that it was purely physical. But this is, again, false. We would agree with opposing counsel that the initial reaction that the brain gives is physical, but that physical reaction is then used to gain the contents of Mr. Denolf's mind. Page 3, paragraph 2 of the record explains that if memory is not present during the FBME examination, the brain will not light up. And for this reason, the physical reaction leads to testimonial information. Now, in regards to the Eighth Amendment, opposing counsel contended that the punishment was not cruel because Mr. Denolf is only suffering from mental depression, and that's common. I would like to point this court's attention back to the evidence cited in Porter v. Clark, in which they explained that prolonged solitary confinement creates a substantial risk of serious emotional and psychological harm. In order to prove a punishment cruel, we must not only look at the current harm, but the risk of future harm. And pursuant to Farmer v. Brennan, prolonged solitary confinement fulfills the objectively cruel prong. Opposing counsel contended that the state provides a valid penological justification of incapacitation. When we look to the facts, when we look to the majority, when we look to the dissent, nowhere does the state provide the justification of incapacitation. The only justification they provide is on page 13, paragraph 6 of the majority, that of deterrence. And pursuant to the standard set within Foreman v. Georgia, which opposing counsel never contended, deterrence is not a valid penological justification within the instant case. Opposing counsel asked me to respond to the case of Wilkerson v. Austin, and my response would be that there was a valid penological justification in that case, and for that reason, it was not considered unconstitutional. Because the state does not have a valid reason to subject Mr. Denolf to this objectively cruel punishment, they are acting deliberately indifferent to that risk, pursuant to Rick v. Shover. It's for this reason we ask to reverse. Thank you.
Thank you.
This honorable court is now adjourned. Thank you so much.
Thank you.
Thank you.
Thank you, everyone.
Thank you, everyone.